Hi viewers. Today in this video let's see the curious case of magic noodles between ITC and Nestle. In this video, let's see how the court ended a 7-year dispute between two FMCG giants over use of Magic Masala and Magical Masala as expressions to market their noodles brands. Before going to this video, I would request you to subscribe 5 Minutes Learning channel in YouTube and support me to post more such videos. Also by subscribing, you can keep track of my video updates. For your better understanding, I have enabled this video with English subtitles. Now let's move to the topic. ITC is an Indian FMCG giant who entered the Indian instant noodles market with Sunfeast Yippee in the year 2010. With two variants, 1, Yippee Magic Masala and 2, Classic Masala. In March 2013, ITC came to know that Maggi has launched instant noodles under a similar mark, Magical Masala. ITC filed a suit against Nestle, seeking a permanent injunction to stop Nestle from using the mark, Magic Masala, or any other similar term for its product. ITC contended that it had introduced Sunfeast Yippee noodles with Magic Masala flavor in 2010, and Nestle's adoption of a deceptively similar expression, Magical Masala, in 2013 to market their noodles, amounted to passing off. ITC had also asked for damages of over 10 lakhs. In its suit, ITC submitted that the public identified and related the term Magic Masala with Sunfeast Yippee, and submitted that Nestle India was passing off the expression. The law of passing off protects the goodwill of a business by preventing competitors from passing off their goods as someone else's. ITC therefore alleged that Nestle India copied the phrase by slightly tweaking it as saying magical instead of magic. By doing this, it said, the company wanted to cheat unwary and gullible customers into buying their product instead of ITC. ITC emphasized that there was nothing magical about the flavor, and so Nestle cannot claim right over using the expression Magical Masala. ITC added that, owing to its excellent quality, geographical reach and reputation, Magic Masala has attained distinctiveness and is associated with ITC alone. Retailers in the trade and public ask for ITC's noodles by the mark Magic Masala. Nestle has, in its suit, ITC submitted that the public identified and related the term Magic Masala with Sunfeast Yippee, and submitted that Nestle India was passing off the expression. The law of passing off protects the goodwill of a business by preventing competitors from passing off their goods as someone else's. ITC therefore alleged that Nestle India copied the phrase by slightly tweaking it as saying magical instead of magic. By doing this, it said, the company wanted to cheat unwary and gullible customers into buying their product instead of ITC. ITC emphasized that there was nothing magical about the flavor, and so Nestle cannot claim right over using the expression Magical Masala. ITC added that, owing to its excellent quality, geographical reach and reputation, Magic Masala has attained distinctiveness and is associated with ITC alone. Retailers in the trade and public ask for ITC's noodles by the mark Magic Masala. Nestle has been losing market share to ITC's noodles, and has therefore resorted to unfair competition by using Magical Masala. Nestle has many variants of its noodles and therefore there is no need of the respondent to use the mark Magical Masala. On the other hand, Nestle argues that it was using Magical Masala as a flavor descriptor. Magical masala conveys flavor and not origin. Magical masala is a laudatory and descriptive epithet, lauding the spicy characteristics and quality of masala, which is sold along with the product in a sachet, by the name of Tastemaker Magical Masala. Nestlé's product is sold under the mark Maggi, having 80% market share. Magical masala or magic masala are common expressions, which cannot be a subject matter of any proprietary rights. Nestlé is using the word magic prior to ITC for its products, and as far as masala is concerned, the same is common word to describe spices. Therefore, combined use of magic and masala by the ITC is not proprietable. Both the parties are selling their noodles under their respective brands, namely, Sunfeast ITC Yippee and Maggi, which appear very prominently on the labels. Therefore, there cannot be any confusion. This is more so in the light of the fact that the products are sold in an entirely different packaging. The words magic masala is widely used not only by the Nestlé, but also by other manufacturers, like Lay's Magic Masala. The court observed that, descriptive term directly and clearly conveys information about the ingredients, qualities, or characteristics of the product or service. The suggestive term only indirectly suggests these things. The court further observed that word or mark, magic masala, indirectly suggests magical change by consuming the ITC product, and therefore, the word or mark, magic, or magical, cannot be considered as descriptive, and it is only distinctive word or mark, having secondary meaning. The court also added that in such matters, the thumb rule under the law is that words or the expression, which and are not distinctive are inherently weak, and are therefore incapable of being registered or protected. Reference was also made to Section 9 of the Trademarks Act, which provides that generic names can never be registered. Relying on evidence, it finds, generally, that magic is commonly used in the food industry. It finds, further and more specifically, that magic masala was first adopted by neither party to this suit, but by Lay's for potato chips. These findings dissipate ITC's uniqueness claim over magic masala. It was acknowledged that, it was in relation to Yippee noodles, that the combination of magic and masala were first used together in 2010. Further, it was also noted that, the phrase magical masala, used for Maggi noodles at a later point of time, was certainly inspired from the adoption of the expression magic masala for Yippee noodles. Pertinently, however, the court has ruled that such adoption cannot be said to be malified. It was a legitimate adoption by the defendant, Nestlé Maggi, as no person can appropriate common and laudatory words. The High Court concluded that, the term was not a descriptor of the product, but rather a laudatory expression, and the same cannot be given, monopoly or protection. Further, the court held that the terms, magic and masala, are commonly used terms by different manufacturers, in the packaged food industry, and it would be unfair to confer monopoly over the same expression. The court also held that there was no scope for confusion, as the competing brands, Sunfeast Yippee, and Maggi, are completely different from each other, and therefore the court dismissed ITC's suit. Exact court order as follows: in my view, neither the plaintiff, nor the defendant can claim the monopoly over the respective laudatory words, magic or magical, along with common word masala to the exclusion of one another. Therefore, neither the plaintiff nor the defendant can dissect a portion of a label and claim monopoly over it. As such, the plaintiff cannot claim monopoly over the expression, magic masala. Thank you all for watching this video. If you have not subscribed yet, please support me by subscribing 5 Minutes Learning channel in YouTube to keep in track of my new video updates.